We're going to use these small group, but apparently for the recording, we'll need to use these. So thanks everybody for coming. Just a really quick background on who we are. We're a tech firm. It's all we do. We only work with technology companies from inception through to public technology companies, many of whom, like Facebook and GoPro, we've been with since they were two founders just getting started. So our expertise is in helping companies scale and grow and eventually being sold or going public. So the presentation today is geared to people who are building that type of company, a company that's technology-based. It's going to be high growth. It's going to raise a lot of venture capital money and be very kind of active on the sort of corporate transactional side. If you're building a different type of business, then much of what we're saying doesn't apply to you. The types of companies where we work with kind of need to, from a legal perspective, look and feel a certain way. And so that's the target here. So if you're starting a different kind of business, you might think, well, I don't need to do that, and you may be right. So just keep in mind kind of the type of companies that we're focused on. And by the way, let's keep this interactive, so feel free to jump in and ask us questions. Okay, so we work with hundreds and hundreds of companies. We represent more unicorns than any law firm out there. We work with Uber, Airbnb, Dropbox. Those are the types of companies we work with. So we see a lot. And we see a lot of companies who come to us maybe from other law firms or from other types of providers, and we have to quickly help them kind of get their corporate structure cleaned up. So the things we're covering today are kind of lessons learned, things we've seen founders maybe not think about the right way from the beginning. So if you're out there and you're thinking about raising money, these are things you need to keep in mind. So first relates to your basic legal structure. So this is like, what type of entity do I have and where is that entity formed? And if you want to raise venture capital, you will need to be a Delaware C corporation. There's really just no ifs, ands, or buts about it. There are other entity types out there. You've probably heard about S corps and LLCs, partnerships. Those entities, they have good. They may work in other contexts, but if you want to raise venture capital money, you'll need to be a Delaware C Corp. So sometimes companies start in like New York if you're headquartered in New York, or maybe California if you're headquartered in San Francisco. And what we have to do is we incorporate the company and move it into the state of Delaware. So being a Delaware corporation doesn't mean you're headquartered in Delaware or that you're carrying on business. It just means that's like the birthplace of the company itself. But the company would also be carrying on business in the state of New York. And so you'd also have to tell the state of New York, look, I'm a foreign corporation, I'm a Delaware company, I'm carrying on business here in New York, and you have to pay New York a certain amount of money every year. It's a few $100s, it's not a lot, and file some paperwork with them as well. So food for thought here. Yes?
Why does it have to be a Delaware company?
So Delaware, pretty much any company you've heard of is incorporated in Delaware. Delaware has the most sophisticated, predictable, corporate laws and judges in the country. And so stockholders and investors are very comfortable with the state of Delaware. People understand what the legal rules are there, how things get interpreted. So it's for everyone's comfort level that we pick Delaware. Yeah?
Are there any challenges with incorporating if the company founders aren't American?
No, there's not, actually. There's no requirement that people be U.S. citizens. So you could be a founder, you can hold stock, you could sit on a board of directors. Whether you can be an employee of the company is going to be tied to your immigration status, and so you'll need to have a visa or kind of work authorization, but that's a different issue than whether you can be an investor or a stockholder or a founder in a startup. It's a good question, yeah. All righty.
Cool. So after you form your company, I think the number one thing after you've structured the legal entity as a Delaware C Corp, like Christine said, is make sure that that company, your company, owns all the IP necessary for your business. And so you think of IP, oftentimes people think in very like registered IP, very strict, narrow categories, like do I have patents, do I have trademarks? This is really more broad, whether you're a hardware company or a software company. It's really everything that you guys are developing and everything that people are working on developing, everything from your business plans to ideas of what the product can do, definitely down to the code of whatever software you are creating. So it's pretty much everything associated with the company. And that's a key asset, especially at the beginning, when really it's founders and the idea that you guys are executing upon. That idea is critical. So you need to make sure that the company owns that idea and no one else does. So from the very beginning, the first thing as you see the first bullet, is you need a clean break from your prior employer. As we'll get on later on, much of this for the same reasons that you'll need to make sure that your current employees are contributing all their IP that they're developing into the company. Your prior employer will have similar kind of concerns, and you'll need to make sure that there's a clean break between what you were doing for your prior employer and what you're doing for your company going forward, to make sure that, you know, as your company develops, you become a huge, you IPO, you become a very popular company. You don't want your prior employer to come back and saying, oh, actually, part of this is mine because you did it on my watch or you did it on my resources. So the first thing to do, I mean, ideally, in a perfect world, you'd stop your current employment and doing what you currently do before you start working on your next venture, on your startup. Obviously, much easier said than done. That's just not how it usually works. So I think it's important to separate clearly what you're doing as part of your job and what you're doing as part of your startup. Number one, an easy way to think about it is the physical resources you want to do. You want to make sure that you're using your own computers, you're working at your own home in your own office, and you don't use your company's computers and your company's resources in your company's office, and more importantly, your company's time to develop that, because they can have a claim of ownership towards that. And oftentimes, the way this works is you need to make sure what you've agreed to before you ever really started working on your company. So you may not have an employment contract with your company, but you inevitably are going to, once you start up, I'm sure everyone has signed a bunch of paperwork. And oftentimes a company's like employee manual or employee handbook is incorporated into things you sign, even if you don't think you specifically signed a contract. So it's good to go back, and once you start working on a new venture, and think about, what is it that I've agreed to already? What are the rules that I'm kind of subject to under my current employer? And I kind of recommend going back, reading employee handbooks, reading any NDAs you may have signed when you first got started, and seeing kind of each company will have, specific rules of what you can and can't do, what they consider theirs, what can be yours. And there's often a policy and procedures there. And I would suggest reading it, seeing what kind of the handbook says, and having a pretty open communication with your current employer, because you may be thinking, I don't want to talk to them about it, I don't want to draw their attention to it. But being on the same page from the get-go is much, much more important, even if you have some hard conversations, than not doing it, thinking that you're kind of getting away with something, and later on down the road have to deal with claims and not sure if you've kind of separated the two entities and the two IPs correctly from the get-go.
Just a couple thoughts. I mean, if you're following the news and you could see the litigation between Uber and Google, that's a very real example of this, right? You had somebody, and we represent Uber, so I'm not going to comment too much, but you had someone who's working at Google, left the company. It's not clear what happened while he was at Google versus after he left. Uber bought the company. It's now Uber's problem. So there's real issues here that can come up later and really undermine the value of your business. Second thing is, this can apply if you're an intern as well somewhere. So it's not just paid employment necessarily, so you need to be aware if you're working somewhere as an intern, doing a startup on the side, you need to think through these issues. I think the reality is, if you're working somewhere and your startup is something completely unrelated to the company you're working at, I think it's less heightened, right? As long as you're doing your stuff on your spare time with your own computers, probably hard for your current employer to say they have a claim. But if what you're working on in your spare time is in any way competitive or related to the business you're working at, there may not even be a way for you to own that separately. You may need to quit before you start anything. So you need to be very thoughtful about these things. These are the kinds of things investors really, really care about and will diligence very heavily. And that can't be the first time you're thinking about it once investors are at the table. You need to think about this from the get-go. And a good startup lawyer, this will be one of the first things they ask you when you go to them for help is, well, what are you working on? When did you start? And what are the circumstances of your prior employment?
So kind of two aspects of making sure that the company owns everything. One is making sure your prior employer doesn't own the IP, which we just discussed. Secondly, making sure that everything is now contributed into that entity going forward. So one is making sure that all the pre-incorporation IP is owned by the company. Now, you may have your co-founders now, and you think, hey, everyone's on the same page, everyone's a team. But going forward, you don't want that uncertainty of people, individuals holding the IP. You want to make sure everything is in the entity. definitely because, as Christine said, investors are going to really focus in on that. And secondly, because you just never know, what your relationship with your co-founders is going to look like a year, 2 years, 3 years, 5 years down the road. And so on the founder side, that's usually done at the very onset when you get your founder stock. And often your kind of consideration for your founder stock isn't necessarily cash that you pay, but you contribute all of the IP that you own, that's your asset. You say, we've been working together, we've developed all these ideas, all this code. The company's now going to own it, and in exchange for me giving that to the company, I'm going to get my shares in the company as a founder. Secondly, as you go on, you're going to hire employees, you're going to have contractors who are going to be helping you grow your company. From the onset, often there's, from the onset, you really should make sure that they sign an IP assignment, contributing everything that they've done and they're going to do going forward to the company, so it's absolutely clear that the company owns the things, the ideas and products they're developing, and not them as individuals. Now, the specific paperwork is going to be slightly different whether that person is an employee or whether that person is a contractor. But the key is to be cognizant of that at the get-go, because once someone's out the door, it's harder for them to get them to sign something, right? You no longer have that leverage. At that point, you're almost just asking for a favor, chasing people down the road, and that's a situation we sometimes see companies, clients that we get coming in, and it's kind of a scramble to make sure that people have signed the right things and that we've kind of covered our bases on the IP ownership front. So it should be just a key step of any hiring or contractor engagement process, just as important as getting them on board and finding the right people is before they really start working, making sure that they sign the proper paperwork so that there's no question going forward of who owns that intellectual property.
So yeah, a couple of extra points. One is I think it's pretty common. You have 2 or 3 founders. They are starting a business. You may not actually have an entity for a little bit, right? You're just kind of working from your dorm room. Until you actually have a legal entity, so the Delaware C Corp we talked about, and each of you takes everything you've been working on and puts it into the company, it's each of you individually that owns that IP. So at any point before that, one of your founders could say, guys, I'm out, and they walk away, without all that IP. The company doesn't yet own it. You don't have a company, you haven't put the IP in. So it's really important to deal with this early. The second thing is I've heard people say, oh, it's fine. I have this consultant working for the company, and he signed an NDA, so we're fine. An NDA actually doesn't do what most people think it does. All an NDA says is, I'm telling you certain things about the company. You're promising not to disclose that to anybody. That's important, but the more important provision is actually IP that you work on, you assign to the company. And a standard NDA doesn't have that IP assignment language. So you need to make sure you're using the right legal forms here, or else, as Felipe said, you're really going to be scrambling later. Because here's what an investor is going to do. They're going to come in when they're looking at you and they're diligencing the company, and they're going to say, I want a list of everyone who's ever worked for the company. Interns, consultants, advisors, employees. I want a list. I want to know when they started, when they left, and what they did. And for each of those people, I want to see the agreement they sign that contains the NDA and contains the IP assignment language. And they're going to hire lawyers like us to look at every single name and every single agreement. And if you don't have them, it's going to be a big problem. So really the only time to do this is to get it from folks the day they start. Yeah?
Are there template versions of these forms for very early, or do you have to go to a firm to get these kinds of forms of language to fill out?
Yeah, so the question is, are there forms out there, or do I need to spend a lot of money on a law firm probably to get them? I think that there are forms out there. I think you can check. I think there's a site called Clerky, I think does some of this stuff. So I think you can find good templates. The reality, though, is if you need to incorporate you need a lawyer to help you with a lot of this. And so we give these forms away to our clients for free. It's kind of part of the standard package when we set them up. So if you're serious about building a business, you should be working with a good law firm, and they'll give you all this stuff as part of working with you.
What about processes and development? It's kind of a gray area of IP. Are there any considerations? Like if I'm working for a company and I'm taking best practices and processes from that company and implementing it on my company, which might not necessarily be IP, but maybe just procedures.
Yeah, it's a good question. So how you do your job and kind of general knowledge in your mind, I mean, you can't separate that in your brain, right? So you've learned things in doing your job, and you're entitled to kind of go on and continue with that in your next job. What you can't use is like proprietary information, so something that's very confidential. If they have a trade secret, for example, or customer names, those types of things you can't use, but kind of general know-how about your job, it's kind of hard to leave that behind. It can be a gray area, though, sometimes, for sure. All right. I'm doing this one right. Yeah, so related to this is, so we've made sure that the company owns all the IP, right? That's super critical. It's like a big part of what the investors are investing in. It's really team and intellectual property are the two big things. So we've gotten it all into the company owns it. What does the company need to do now to make sure that the company has the protections in place? And you know, when you talk about intellectual property rights, it's kind of like a basket of rights. There's different tools within the basket that you can use, and which tools you use depend on the type of company and product or service you're building. And most companies use, you know, more than one. So the first kind of formal kind of IP protection is trademark protection. And that is when you think about your company's logo, name, brand, marks, so the Nike swoosh or, you know, your brand name, those are the kinds of things that you need trademark protection for. And so there's formal filings you do with the US Patent and Trademark Office. You know, it can be complicated because you need to decide which jurisdictions am I going to file in, right? Am I just US focused, or am I looking at Canada, maybe the EU? Each of these jurisdictions has their own filings. Now, a US lawyer here can coordinate all of this, but you need to be thinking, well, which are the countries that I want protection in? Not just today, but down the road. Secondly, you know, what are the categories, right? The USPTO, they think about trademark protection in categories. Are you building a business that sells sweatshirts? Or is it, you know, software as a service? Is it, you know, consumer electronics? These are all different categories, and you need to file in all the categories you're thinking about. So, this is an area where you kind of need to be thoughtful about your business, not just what your business is today, but where you see it going. And so I think, you know, this is an area that you need to kind of think about actually earlier rather than later, because a lot of companies spend a lot of time and energy thinking about their name, right? Their company name, their brand, their logo. What you don't want to do is spend a ton of time and a fortune, you know, investing in that name and logo and having customers recognize it. And then lo and behold, you get a cease and desist letter from somebody who actually has the rights to that name. It's a really expensive mistake, and it can really set a company back. So you can do things early on before you get too invested in a name to figure out, is this the right name? And if it's not, that's fine. I'd rather know now, and we can go on to plan B and deal with it now. So trademarks is super important early on. Actually, let me make one important point there. I think some people think because they're able to name their company a certain name that they then have all the trademark protection they need. Actually, the two are not related at all. So when you pick a company name, one of the things we ask, we have companies fill out a questionnaire when they're getting started. It asks the founders a whole bunch of questions, one of which is, what do you want to call the company? And they'll give us a name, and all we do is search the Delaware Secretary of State website. Is the name available? All that means is there's not another company incorporated in the state of Delaware with that name. And so if the name's available, then we can incorporate the company. But that doesn't mean you can use that name from a branding, marketing, trademark perspective. That's a whole other analysis. Because there could be a company incorporated in California that's using that name, or maybe they're incorporated under some other name, but it's their, you know, brand name, or DBA. So just because you pick a company name and you can incorporate under that name doesn't give you any protection on the trademark front. Okay, second type of IP protection is patents. You guys are probably familiar with patents. Patents protect inventions, really, but they're broader than that, too. They can protect software code, lots of different types of inventions. And unlike some other IP areas where you have some rights just by kind of operating in the market, patent protection only exists when you actually make a filing with the Patent and Trademark Office. And timing matters. So you need to basically make your filing within a certain point of time where you disclose your invention to the public. That's now the law. I think it's within a year. That's the law in the US. It's actually different in some other countries. So if you're thinking about an international strategy, you need to be thinking about patent filings before you tell anybody about your invention, anyone outside the company, really. So another thing you need to at least think about super early on. And some companies, you know, they're building a SaaS business, or an app, and patents aren't super important, and that's fine, but you should at least, kind of be thoughtful about it at the beginning and decide maybe we'll tackle this later. Copyright is basically any works of authorship you have copyright protection in. So typically you think about like a song or a novel, something that's an expression, that has copyright protection. But software code is also a form of expression, and there's copyright protection in that. And some protection you have just by virtue of creating it, some you have if you actually make copyright filings. So just an area that you have to think through with your counsel. Last is trade secrets. Coca-Cola formula is kind of the famous quintessential example of this. So this is, it's not a filing you make. There's no special notice you have to give to anybody, but it's something so core to your business that you basically keep it under lock and key, and only a very few, a handful of people at the company know what this is. It's like on a need-to-know basis. And then you have protection in this really by virtue of just keeping it very secret. And you may decide that some of the things you do, like processes and things like that, maybe they're not eligible for patent protection, they're not a good candidate, so we're just going to keep this under lock and key and only tell a few limited people, and that's going to be how we keep value in that. All right.
So now you've made sure that the company owns all the IP related to the business. The next really key step at the outset is making sure that you own that company and the right people own that company. Because there's kind of just as important as the dispute over, who owns this IP that we're using. Even if you secure that, the next dispute up kind of the corporate chain would be who owns this company, which is just as important. So from the onset, and I kind of touched on this earlier, it's really important to make sure that the founders have properly documented ownership. Now, one mistake, and I've seen this with a few of my clients, that a lot of founders make is they think, I founded this company, I incorporated this entity in Delaware, that's all I need to do, it's obvious that I'm the owner of it. And that's not true. Like other people, you can have incorporators who are not the owners. So it's really important from the get-go to make sure that you have properly documented ownership documentation, and that's usually done through a stock purchase agreement where the company itself is going to issue stock to the founders. And again, you don't have to pay cash for that often with the founders. As we said, it's IP and other assets that you're contributing into the business in return for which you get your stock. One thing, just a technical point here, especially at the beginning for really early stage startups, make sure that you do what's called an 83B filing. So we'll get to vesting in the next slide and why that's important as a retention mechanism. But what 83B filings will do is, without making them, you're going to get taxed on the value of that stock as it vests and as it becomes fully yours and disposable by you, and is not what they call subject to forfeiture. And as you can imagine, you're a really early stage startup now. You hope your company is going to grow. It's going to become massive. It's going to become super valuable. It's not that right now. You want to get taxed, if at all possible, and to the fullest extent possible on that value now, because it's a much lower value. If you get taxed over the next year and 2 years and 3 years and 4 years as you vest, you're going to have to pay just a lot more money to the IRS, because those shares are going to be just worth a lot more. So that's a key point, but important. A lot of people lose a lot of personal value to the IRS by not filing the 83B when they get their stock at the beginning. Just as important as documenting founder stock is making sure you're properly documenting any equity grants, whether they be options or stocks that you're giving to your employees and your contractors and your advisors. Now here, I think there's two important things. One is be careful from the beginning who you're promising equity to. A lot of times founders have conversations about equity and point grants that are probably a little more casual than they should be. These are important conversations, and you need to be very clear who you're promising equity to. And you don't want to, you want to be on the same page. You don't want to have a conversation with someone where they think that, I've been promised a part of this company now, and in your mind, that's not a grant that you've tallied in your head. So one, be very careful of these conversations from the beginning. And two, once you have those conversations and you do intend to promise someone equity, get that papered and get that documented right away. Because as time progresses, what people think they agreed on gets murkier, and that just leads to more disputes down the road. So as soon as you kind of make an agreement with someone, document that right away is absolutely the best practice.
This is something investors can't worry enough about, right? They worry about what we call the fifth beetle problem, which is there's somebody out there who thinks they own a piece of the company, and when the company starts to do well, these folks come out of the woodwork. And we've seen kind of very public examples of that with some companies. Because when investors invest, right, they're very methodical institutional investors about this. They're writing a check for X, and they are going to own Y% of the company. And if there's somebody out there who owns stock who's not accounted for, all that math is messed up. So when we work with companies, we spend a lot of time saying, is there anyone else out there that you've made a promise to, whether verbally or in writing, and we need to deal with that and clean it up. The other kind of related point we see is I've seen founders early on make commitments to people in emails or their own homebrew legal documents where they promise people a certain percentage of the company. We would never let our founders do that. We only ever speak in absolute share numbers because percentages are of what and measured when, right? Is it 5% in perpetuity? Is it 5% measured today? I mean, it's just a nightmare. And I've seen this become a very expensive problem for people. So the short answer is you should work with counsel before you document any issuances. You shouldn't be out there just willy-nilly promising people, a slice of your company. It's really a headache later to try and clean up.
And one other point here, the last point there, it says don't grant stock options without a valid 409A valuations. I think it's just a quick moment to pause. A lot of people talk about equity grants, so just equity, but there's a difference between granting someone stock and granting someone an option to purchase stock down the road. From the get-go, as an early stage startup, you really should only be granting restricted stock until you have done what's called a 409A valuation report. That's a technical IRS issue, but you really can't be granting people options that are already in the money at the time of grant. That's a huge problem for both the employee and for the employer.
Do you guys know the difference between stock and options?
Yeah,
who here has worked at a startup, by the way? Has anyone worked at a startup? I mean, usually if you work at a startup that's been around a little bit, you get stock options, right? That's different than what we would call restricted stock or founder stock usually. So when founders get their shares in a company, it's not an option, it's stock today. So they get it, they pay for it, usually by assigning some of the IP and we talked about. They own the shares, they can vote the shares, their long-term capital gains clock starts, they're theirs. Now they may be subject to losing these later when we'll talk about vesting, but until they lose them, they're theirs. That is very different than a stock option. What a stock option is it's the right to buy the shares later at today's price. And usually the later is once those shares are vested. So you get them at the price when you join the company, and if they're subject to like a 4-year vest, by the time you go to exercise them, those shares are probably worth a lot more, but you get the old price. So you're not actually a stockholder till you what we call exercise, or you basically pay for your shares, but it's the right to acquire shares later. And most companies, once they've raised a round of venture capital money, they start to give options to employees, and that's kind of the currency of equity for people who join a startup.
And then the options are based on that series of funding?
Not, well, sort of. So founders and employees get common stock in a company. It's kind of the most basic level of ownership. Investors get preferred stock, which has certain bells and whistles. And in an event of a liquidation, the preferred basically get paid first. Common stock is always valued at a fraction of the preferred, and the number changes, but I would say in an early stage company, it's anywhere from 15 to 25% because it doesn't have all the bells and whistles and protections. So if your company sold preferred stock, and let's keep it simple, to investors at $1 a share, probably the options granted after that are going to be like 15 or 20 cents a share, something like that. Now the hope is eventually when the company does well, everybody's going to get that higher price down the road. But early on, because the preferred stock ranks ahead and it has all these protections, it's always worth more.
And the relationship between the rounds of funding and granting options is not necessarily like a technical issue where, oh, I've done my first preferred stock round and now I can grant options. Just that's kind of a proxy for the maturity of the company and how much value there is and when it starts making sense to both issue options and kind of get the infrastructure in place that you need to issue options. So next we're going to talk about equity vesting. So not only is it, we've confirmed who owns the IP, the company owns the IP, We've papered and made absolutely clear who owns what percentages of the company. But when you're giving equity, it's important to, vesting becomes important as a way to keep people around, a talent retention mechanism. You can imagine a situation where we start amongst the founders. Imagine a situation where you have a few of your co-founders, everyone gets their stock today, and one person just leaves. And and that stock, if that stock isn't subject to vesting, you lose all that person's value. You lose, they're no longer contributing to the company. They're no longer spending their time and their sweat working for the company. But you are, and your other co-founders are, and as this company grows in value, this person is just going to be a free rider. Their stock is going to be increasing in value together with yours while they're not contributing. So one solution that the market has come to protect from that problem is what's called vesting. And vesting is essentially what Christine says is, okay, you get 4 million shares today, but the company can pull those back and you can lose them so if certain things occur. And as you stay along with the company, you kind of get to keep those permanently. The more time you devote and the more effort you devote to the company, you get to keep those permanently. And usually there's a vesting schedule. It can vary. For founders and early employees, where the market is at right now is what we call 4 years with what we call a cliff. And so what that is it's 4 years monthly vesting. So every month I get 1/48 of my stock. And 4 years down the road, I get to keep it all. So that's a way of saying, okay, if you stick around for 4 years, if you put in your 4 years, that's a lot of investment. That's a lot of time for you. And from that point forward, you can leave and do whatever you want. That's your stock. The 1 year cliff is what we say is that, okay, that's monthly vesting. But for the first year, you actually don't get that 1/48 every month. You get nothing until the first year. And then you get a quarter right after that first year is done. Because there's although it's linear to some extent, right? Value isn't completely linear. If you stick around for 2 months and leave, that's really not worth anything to the company. So you shouldn't get those 2 months worth of vesting at the beginning.
It's also a chance for companies to take a bit of a look at people. So you hire them, they look amazing, but sometimes people don't always work out. And so there's kind of a year's period there where you're making sure people are a fit for the company. And if they're not, and you either terminate them or they leave within that year, they don't leave with any equity. Once you hit your cliff, then Felipe said you get a quarter or 12/48 on that 1 year anniversary. And that's a standard vest for employees and for founders. Yeah.
So I get that this wouldn't, entirely eliminate some of the issues with, pulling back a vest on somebody who, is with the company a short period of time. But is another alternative, diluting them down effectively, where, you might have some, a partner initially, they leave after a short period of time, and you issue additional shares to whoever's sticking around.
Yeah, I mean, dilution can't be targeted, right? It dilutes everyone proportionally. So you can, rise all boats, or the tide goes up for everybody, but you can't just single people out and dilute them. Dilution's a natural thing at a company. In some ways, it means the company's doing well. So dilution only solves really part of the problem.
I guess what I was getting at is issuing more additional shares to the folks who stuck around.
Yeah.
So let's say you had 2 partners, one of whom leaves. The remaining partner, you issue additional shares for it. That'll effectively breeze them up.
It will, but for some technical reasons and this came up in the movie The Social Network, it's if you're kind of really paying attention. Delaware law says you actually would need a disinterested vote then, probably. So if you had 3 founders and one of them left and the 2 remaining founders comprise the board of directors, you couldn't basically just approve more stock for yourself. You'd actually need to get that third person's approval. So it's not that easy necessarily to just kind of give yourself more equity. Obviously, the more people around the table, that does get easier. But that sort of singling that person out by just giving yourself more equity. So it's actually can be tough to achieve. But vesting solves for it very nicely. This is an issue for founders. It's a sensitive discussion I probably have a few times a month. I think founders feel, and I understand this, I think they feel very reluctant to have vesting on their shares. But it's the reality of building a tech company. And as Felipe said, one of the reasons is to protect you vis-a-vis each other, right? Because you have, the free rider problem. People leave for good or not good reasons. And then, the remaining founders are left holding the bag. Secondly, venture capitalists will insist on vesting. It will be something they will look at as part of your term sheet negotiations. They'll want to know what your vesting is, and they'll make a decision as to whether they think they need to put you on something else. And yeah, they need your approval, but you want their money, and so you may have to agree to this. So what I tell founders is, look, let's put you on something normal to start. Market, which is 4 year with a 1 year cliff. And they're unlikely to touch that, actually, because it's market and it seems a little bit petty. But if you don't have vesting, or you have weird vesting or really short investing, then they feel like, you know what, you didn't play the game and I'm coming in to renegotiate this now. So I think you just do what's standard. I think the other really compelling reason is, and look, all the founders you hear about, Zuckerberg, Spiegel, these guys all had vesting on their shares, believe it or not. Now, they stuck around at the company long enough that it never mattered. But everybody you hire, you want to put them on a vesting schedule, right? You just have to, 4 years at the 1 year cliff. And it's very powerful to say, look, I was on the same vesting schedule. Everyone here is on the same vesting schedule. And it's very hard for them to argue with that. So I think there's lots of reasons to do it and to do what's standard.
Yeah, and just part of what Christine just said, to piggyback off that, if you don't have something that's standard, or you don't have something at all, oftentimes when a VC investor will come in, they'll be even more aggressive on the front end and ask for something. We'll try to get a vesting schedule that is even worse for you. So if you have, a medium market, solid vesting in place from the beginning, at the end of the day, you'll probably be better off. And so another part of vesting often people talk about is acceleration. So you have vesting. The company has the right to, revoke those shares if you leave or get terminated for certain reasons. But what happens if you sell the company, right? And that's when often things get accelerated. And so you often hear the term, is it a single trigger or a double trigger acceleration? And what the triggers there define to what events need to happen for you to get all those shares vesting accelerated. And what accelerating vesting means, it means that 4 year schedule is no longer applicable, and if certain events occur, you get all of those shares immediately. And so the double trigger is usually an exit. It's a sale of the company, coupled with you have to be terminated subsequently, or they have to really diminish your role. So sometimes people try to get around the termination requirement by, you sell your company as a founder, you now work as part of a much bigger company, and they demote you, or they try to move you across the globe. And so those usually qualify as the second trigger. And as an exit partner, a company that's going to try to be buying your company, often they really will require double trigger acceleration for early employees and founders. And that's because your company is very valuable, your customer base is valuable, your IP is valuable. But if for a startup, the founder team itself is a lot of the source of value. So they want to be sure that those guys are still around after they buy the company. A single trigger means, if you buy the company, all that stock is mine and I can cash out and leave. And that often scares your exit partners off. So that's why the double trigger is important there for founders. Oftentimes you'll have advisors, people that don't necessarily sit on your board, but are part of your advisor board and have a lot of connections within the industry, over a lot of expertise, and they have helped you kind of build your brand and build your company to where it is today. Often you see single trigger for those people because that's a little bit different. They're not day-to-day operators. They're not part of the team really driving this forward, but you use their connections and you use kind of their expertise to get to a certain point. And this is kind of a reward for them when you get to an exit is, listen, you've helped us get here. Thanks a lot. You get accelerated and you can leave. But that kind of thought process doesn't really make sense for the day-to-day operators that are really there driving the company's value going forward.
Any questions on vesting? Does that come as a surprise to people? The whole concept of vesting? No? Okay, that's good. All right, employment laws. So this is an area where I'm going to tell you what the law says, and then we'll talk about what I see people do as a real practical solution, which I'm not advocating. I'm just telling you what goes on in the market. So people who work for a company, the law says you fall into one of two buckets. You're either an employee, and that could be part-time or full-time, or you're a contractor. People call that a consultant. An advisor is just a fancy contractor. Whether you're one or the other, is not what you want to call somebody or how they think of themselves. There's actually, I think, a 12-part legal test that is developed over time to determine whether someone's an employee or a contractor. And this legal test looks at things like, does this person have regular hours of employment, or can they work, in the middle of the night? Do they have the day-to-day responsibilities, or do they just, come to us with a deliverable that we've asked them to do? Do they have a boss, or do they just kind of do the work on their own? Do they use their own computer? Do they use the company's computers? All these tests which try really and get at kind of control, meaning who's directing and controlling this person? Is it the company, which would make them an employee, or is it truly a contractor where it's like very project-based? You send them away, and then they come back with a certain program they've written or something like that. So it's a complicated test, and the reason it's important goes to things like minimum wage laws. So if somebody is an employee, then federal and state law says you have to pay them minimum wage. I don't know what minimum wage is in New York these days. Is it like $12 or something? I don't know. But if somebody's an employee, you absolutely must pay the minimum wage. You must withhold taxes and FICA and Social Security and all that, and remit that to the government, and they get the net proceeds. If somebody is truly a contractor, then none of those obligations apply. You pay them, the gross amount. If it's a project basis, $10,000 for the project. They deal with their own taxes. So the treatment's very different. And in a startup where cash is super, super lean and you don't have a lot of money, even paying somebody minimum wage may not be practical. So minimum wage laws are there. Founders are employees, technically subject to minimum wage. So if you want to be legally compliant, you need to be paying yourselves as founders minimum wage and all of your early employees minimum wage as well. I can tell you, most of my startups in the very, very early days probably don't comply with that because they don't have the money and they run the risk. They think, well, we're going to run the risk, and the second we have funding, we'll start to pay people probably more than minimum wage. But between starting the company and actually getting funding, they're going to run the risk. And the risk is that the state authorities find out and they come after you for failure to pay minimum wage and all the associated fines and penalties. And actually I was on the phone with somebody when we were coming down here with a company. It's a real example. It's a great company. They have now raised 2 rounds of venture capital funding. Took them a little while to get there. So for the first 3 years, the founders and the first 2 employees, they didn't pay them anything. And then they got funding and they brought everybody up to more like market salaries actually. But for those first 3 years, people weren't paid. And they just recently fired one of those early employees. And sure enough, within 2 weeks of being fired, we get a letter from a California lawyer. It's a California company outlining all the money that should have been paid to this person, plus the fines, plus the penalties, blah, blah, blah. And this company's now, they really don't have a leg to stand on. They know that. We're just trying to settle this for as little as possible. It looks like it's going to probably be $300,000. So it's a real issue. I think founders think, well, I'm not going to report myself. And that's probably right, unless you have a founder who leaves under bad circumstances. But your early employees, they may not be around forever. And at some point, things may not end nicely, and they report you or threaten to report you. So I just flag it because I get the realities of starting a business and not having money to pay people, but it's not without risk.
So would it be more advantageous then to have people who are working on your startup with you at an early stage but not founders, to have them under a consulting agreement?
Yeah, I think that's how people deal with it. The problem is I think many of those people, we dress them up as contractors, but they're not actually contractors. And then you have what's called misclassification, where somebody looks at it and says, well, that's nice that you call this person a contractor, but actually if you really look at all this 12-part test, they're truly an employee. But I think it helps, right? I mean, they've signed on a consulting agreement. They've, I think you can try and dress it up that way. It's not bulletproof, though. The other area I'll flag here is interns. People like to use this term for basically cheap or free labor. Minimum wage laws do not apply to interns, but whether someone is an intern is actually a very limited circumstance. It's basically someone through NYU who's, I'm simplifying here, but they're basically getting course credit for going to work at your company. It's not just somebody who happens to be a student or is willing to work for you for nothing. That's not an intern. You actually do need to pay the minimum wage. There's been a lot of press around this lately for people who hire interns, don't pay them, and then the interns come back later and say, look, I was an employee, you owe me minimum wage. Yeah.
Okay, so let's say not under C corp structure, but let's say under like an LLC structure.
Uh-huh.
If you're either an LLC or a sole proprietor, do you you would be considered an owner of the business?
Mm-hmm.
Do you still you can operate that business with 0 employees though, or would you still be considered an employee of the business?
I mean, you would have to probably have at least one employee, you yourself. I mean, if it was, well, as a sole proprietor, you're not an employee, right? Because it's your sole proprietor. An LLC would have employees for sure. Yeah, you would need at least one.
Even if owner and employee was one and the same?
Yeah, I think as an LLC, you're still employed by an entity, so I think there would be minimum wage requirements there. Yes. Yeah, you're probably a K1 holder though for getting paid by an LLC. I'm not sure, but yeah. Well, only if you were only an equity holder. But yeah, I think the issues come up with an LLC. It's a flow-through tax entity, but it is a separate legal, entity for tax purposes. So I think the same issues come up.
So what if the company itself? Okay. All right.
Does that answer your question? Yeah. Okay. Okay, so I think the other thing to think about, so when companies come to us and they're getting started, we sort of triage things for them. It's like, look, you're pre-funded or you have limited funding. What are the real things we need to tackle right now, and what can we wait on? And so we kind of help them prioritize their legal needs with the goal of just doing the basics until they actually have funding. And so definitely all that corporate stuff we talked about, right? Stock and incorporation, that's like number 1 on the list. Probably trademark protection would be, an IP protection would be number 2. And what you're building and time to market, will factor into all of that. But thinking about IP stuff is number 2. And then I think number 3 is probably terms of service privacy policy. If you're launching, right? If you're gonna have a website or an app, or you're interfacing with people in any way, which some companies these days are pretty quickly, right? Because it doesn't take a lot of money to, get something up and running. And so you need to think about terms of service in terms of what are the terms under which your users are interacting with you, or if you're collecting any identifying information, how are you dealing with that information? If you're in the healthcare space, do you have HIPAA to worry about? These are things you need to think about super early and get basic terms of service and privacy policy in place. Those will evolve over time as your business evolves, and frankly, as you have more money, you may think about more robust things later, but you need to get a basic set of terms and privacy policy in place pretty early.
So much like complying with employment laws is going to be critical for the beginning. Going back to issuing stock both to founders and to your employees, and then definitely to investors as you grow and start taking third-party money, you're going to have to be. It's important to make sure that you're complying with securities laws too. And sometimes, especially at the early stages, you may think, oh, I hear the context of the SEC in the context of IPOs or the context of investigations of these large public companies. That must not apply to me. But it does, and it always does. The SEC, which is the United States Federal Securities Regulator, they require, you essentially need a registration for every single sale of securities, or you need to specifically find an exemption from that registration requirement. And similarly, every state will also have securities laws filings and rules that you're going to have to comply with as you're selling stock. As an early stage startup, it's easy to find the exemption everyone kind of relies on is what we call private placements. If you're not doing a broadly distributed offering, if you're offering to very targeted audience, small number of people, that's going to be usually the exemption you're going to rely on. But you should contact counsel and get advice specifically to make sure that your specific issuance of equity is going to comply with those. And then again, at each state level to make sure whether the exemption that you find at the federal level is also going to exempt you from state filings, or what state filings you're going to have to do. So,
I would think of things in 2 buckets here, right? I mean, like Felipe said, if you're not a public company, which none of you are going to be for a while, you need an exemption. And there's really, I think, practically speaking, pretty much only 2 exemptions that people fall into. One is for people who are working for the company. There's an exemption to let you give equity to your team and your employees, but you have to do that in a certain way. You need to set up an equity incentive plan and issue shares or stock from that plan, which Startup Council can help you do. And the SEC recognizes a need to give equity to your employees and contractors, and so they give you an exemption, but you got to do certain things to qualify for that. That's one. Two is basically investors is another exemption, and that's, at its essence, people have to be accredited investors. And we've put up the test here, so it's $200K in annual income, $300K if you're married, or $1 million in net assets, excluding your home. And I think some people think, well, I'm doing a friends and family round. I've actually had a founder say, but I'm relying on the friends and family exemption. That's not an exemption, actually. That's just a term of art people use. Those people still need to be accredited. So you got to be really careful who you take money from. We have our founders, when they're taking investment, give people a questionnaire that verifies that they're accredited. They just check a few boxes and they sign, and they say, yeah, I'm accredited. And we don't have them look at tax returns or anything, but if somebody is taking affirmative steps to basically say that they're accredited, we can take them at their word as long as you don't have reason to believe that they're lying to you. So you just got to be really careful about how you raise money. And the SEC's gone on record in the last year saying they're really taking a look at private companies. Because you're seeing private companies have a lot of value now, right? You have the Ubers and Airbnbs of the world. And so a lot of money is going into private companies. It never used to be the case, right? Companies used to go public after like 5 or 6 years. And so most of the value was actually in the public markets, which are heavily regulated. It's not the case anymore. So as a result, the SEC is taking a careful look at private companies generally, including early stage ones. And one of our partners got a letter. Well, the company got a letter. They had done some fundraising, and there was some press around it. It was a Series A company, and they hadn't done the filing they should have done for their accredited investors. And the SEC sent them a letter saying, hey, we saw your press. We don't see a related filing. What's up? And so, $15,000 later, we had an answer for the SEC, but that's not fun or how you want to spend your money early on. So you need to pay attention to this. Sorry, I hijacked your slide.
No, that's absolutely true. That's absolutely right. And I think, go ahead.
I was just going to ask, so if you had an investor fill out this questionnaire and they came out that they, confirmed they were an accredited investor, you had no reason to believe otherwise, would you be liable if later on you found out that that person actually hadn't been an accredited investor?
Yeah, it's a good question. The question is, what if somebody lies to you and you have no reason to believe they're lying to you? I think these laws are put in place to protect the investors, right? They're not really to kind of protect the companies. They're to protect, widows and orphans, right, from, basically being suckered by companies. So it's really at its core consumer protection legislation. So if people are not accredited investors, they could later have what we call a right of rescission, meaning the right to get their money back. I think it'd be harder for somebody to make that case when they have gone on the record and lied to you and you didn't have reason to think they were lying. So if they told you they were accredited, but you knew they just couldn't be accredited by their lifestyle, that's one issue. But if they seemed like they could be and they told you they were, I'm not saying the SEC may not slap your hand, but I think it'd be a harder case for the investors in the SEC to make out because you have to act reasonably. Yeah.
How would you do this if you're crowdsourcing?
Yeah, so that's a good question. So people use crowdfunding in a few different ways, right? I think often when people think of crowdfunding, they think of Kickstarter or Indiegogo. Those are not equity crowdfunding sites. Those are really people who are paying you for early access to your product or market. They're pre-sales. Those people are not security holders in your company. So for those types of sites, these rules don't apply because you're not selling securities. You probably heard press lately, though, around some equity crowdfunding sites. I think Seedvest and some other ones like that. Or AngelList is a good example. AngelList actually has, they're taking advantage of a change in the law related to what we call general solicitation. I don't want to get too technical, but basically you can advertise for your sale of securities, but it still has to be to accredited investors, actually. The true crowdfunding around equity has actually not taken off, even though there's some legislation out there that enables it, so to non-accredited investors, because the rules they've put in place, the SEC, to let you take advantage of that are so onerous that you would probably spend more in legal and accounting fees than you would in money raised. So The short answer is, at least in the foreseeable future, if you're going to raise money for securities, so stock in your company, can only be from accredited investors. Okay, so you have your equity founder stock in place, you have employees, you're paying them minimum wage, they've all signed invention assignment agreements, and you have your IP in order, and so now you want to go out and raise money from investors, so seed capital. And the question is, how do you think about structuring that? And there's a few different ways. The market's changed a little because it's kind of cheaper than ever to start a company now. So it used to be like the first round of funding into maybe 10 years ago was $5 million because people needed that, right, to build out servers and all kinds of things. With AWS and other things have changed, so people can start companies or make a lot of progress with like $1 million. So as a result, these first seed rounds have gotten smaller and smaller. And when you think about that first seed capital that comes in, there's really, I think, two ways to structure these. And how you structure them is going to be a function of how much money you're raising. If you're raising less than $2 million, then almost always these things get structured as a convertible note. Sometimes a SAFE, which we'll talk about, but a SAFE's really a convertible note. That's typically the way these things get structured because it's not a ton of money, really, and so the goal is to get that money in the company quickly and cheaply and get back to work on kind of building the company. Convertible note or convertible debt is really just that. It's debt when it comes into the company, so these people are giving you a loan, but when you eventually go raise that priced round, so you go raise your Series A and you sell preferred stock, all that debt, those note holders' money, it will convert into Series A stock later. But in the time being, it's debt. And so there's really only a few things you need to negotiate at this stage, which is, well, like, what's the total amount we're raising? South of $2 million. Usually it's around $1 million. What's the interest rate? And I would say 4 to 6% is pretty standard. We've seen those rates come down a little, though, so I've seen them as low as like 1 or 2%. And most importantly, when that debt eventually converts to Series A, what are the terms at which it converts? And here we have what we call capped and uncapped notes. So an uncapped note means that when your debt holders convert their shares, it's just at a straight discount, usually 15 or 20%. So if your Series A shares are being sold at $1, let's say, your new investors are coming in, they're paying $1 a share, your note holders' money will convert in and they'll pay like 80 or 85 cents a share. So their money goes a little further. It gets them more shares for the same amount of money. That's to compensate them for the risk they came in earlier when the company was more risky. So that's an uncapped note. Well, a capped note is just that it has a cap. And what that means is when that conversion happens, the investors convert at the better of, for them, that discount or some valuation cap we set today. So if you had a $5 million valuation cap in your notes and you eventually did your Series A at a $10 million pre-money, your new investors are buying it at the $10 million pre-money price, but your note holders convert at the $5 million, so basically their money goes twice as far. Once again, that's to compensate them for the risk. And the capped notes came into existence because an uncapped note, which is just the discount, investors were uncomfortable because they have no idea how much their debt will convert into. Like if you really hit it out of the park and you raise it a super high valuation, their money doesn't go very far in terms of ownership percentage. But what a cap note does is it gives them some price protection. And they're thinking, okay, no matter how well you do, no matter what crazy pre-money you raise at, I know my money converts in at $5 million, so I can roughly calculate what percentage of the company I will own.
So that, yeah, I mean, caps do get negotiated, right? So I mean, originally people use convertible debt instruments to kind of, especially at the early stage, to try to minimize the complexity of negotiating capital raises. And you don't want, things are unclear at the beginning. It's a young company. You don't want to get into valuation discussions with your investors that early. It's expensive and it's really unclear. So that's where the uncapped notes originally started. But now, with a cap, you will get into some discussion about valuations in future rounds. And so if you use a cap, it's important to kind of hit that right strike price, right, where you're low enough where you're giving your convertible note investors good value and inducing them and rewarding them properly for giving you that high risk loan at the early stages, but high enough where you're not leaving, a ton of value on the table at your next priced Series A round.
Does that make sense? Do you guys understand how the notes work? Okay. They're very, if you stick to standard terms, they're really easy and efficient to put in place. And so you can, as long as you have kind of reasonable investors, you can bring your money in pretty quickly without spending very much on legal fees, which is good. Yeah.
So as a founder, would you prefer uncapped conversion?
Yeah, that's always better if you can do it, right? Because then no matter what valuation you raise at, you just have to give your note holders a bit of a discount. I think most founders don't get away with that for the reasons we talked about, but you can try, sure. Yeah. Cool. You want to talk Series Seed?
Yeah.
Go ahead.
So if you're raising a little bit more money than the $2 million, if you're got either a really capital intensive business where you're going to need a lot of money from the onset, or via relationships or early success of your product, you have a lot of funding available to you, you may skip the convertible round altogether, or between your convertible round and a true Series A round, do what's called a Series Seed funding. And that's real preferred stock. So that's not a loan right now that in the future round is going to convert into stock. That's something that you negotiate price and terms from the beginning. And because of the size of these rounds, it's going to start resembling a real Series A stock in kind of its terms right away. And it'll depend on the size of the round and kind of how condensed the investor base is. But if you have a really sizable Series Seed round, often a representative from that round is going to be able to negotiate a board seat, and you're going to have it may have a liquidation preference, and so it's kind of like a Series A convertible, Series A stock light. So it's going to be a little bit lighter on the terms. You're going to want to streamline the negotiation and the paperwork for it, but it's going to start approximating what like a really negotiated Series A priced equity round is going to look like.
I think that the choice between the two is primarily driven by how much money you're raising. And so if you're raising more than two, I think for a lot of investors, they think, that's much more money. I think it's worthwhile for us to, go through the exercise of doing the full priced round. Spend a little bit of that on legal fees, but so I think it's largely driven by that. Look, I've seen very high in demand companies, raise a $10 million convertible note, and I've seen some companies forced into a price round at $1 million. I mean, those are outliers on both ends. I think for most companies, the $2 million is kind of the natural tipping point.
Where if an investor is going to give, significantly more money, they're going to want the protections that you get with a Series Seed, and they probably won't feel as comfortable with the loan and that is involved in a convertible round. And lately, you want to talk about safes?
Yeah, go ahead.
So what's kind of been popular the past few years, because Y Combinator started this, so it's kind of been trendy, is what people are calling a SAFE, which is a simple agreement for future equity. And what this essentially is, it's a short piece of paper. It was done to streamline fundraising processes and making it as cheap as possible. But it's a convertible note without a maturity date and without an interest rate. So it becomes kind of unclear on your books if since there's no interest, and since it's really never due, is it a piece of equity or is it a piece of debt? And from an accounting perspective, it's not great when you don't know how to treat this instrument. And there's really, Christine can talk a little about this, but there's really a lot of the advantages that's supposed to create. I think it's just as easy and just as quick and just as streamlined as a convertible note. And people are like, I don't have to negotiate an interest rate or a maturity date. But if you as a founder want to do something as a seed, and you should want to have a convertible piece of instrument to bring money in the door, you can agree with an investor to a really, really low interest rate. The lowest legally mandated is like a little bit under 1%. And so that's going to be, and you can put a short maturity date on it. And so those are two really super easy issues to solve for while keeping it clear that it's a piece of debt. So the SAFE, really, it's become trendy, but it's kind of, it has a lot of lack of clarity, which is a pretty big risk from an accounting and kind of business management perspective, to solve for two pieces solve for two issues that are pretty easy to solve and aren't pretty big problems from the get-go. So although they're kind of trending lately, I think we favor convertible notes as
Yeah.
an early round.
The other problem with safes, I totally agree with that. The other problem with safes is there are a series of one-off agreements. So I have a safe with you, and I have a safe with you, and I have a safe with you, and they might be on all different terms. What often happens, by the way, a convertible note facility is, it's just that, it's a facility, and everybody comes in under the same terms and basically under one set of documents. The beauty of that is you often need to amend these things later because you need to extend the maturity date, or heading into a financing, the investors want you to tweak the notes a little bit. With the traditional convertible note structure, you can do all that by acting by majority of dollars. So you go to your couple of big holders and they get it, and you change the terms for everybody basically. With the safes, I need to go to you and get your consent and get your consent. I mean, you're just like herding cats and dogs at this point. And the safes also have, it's very technical, but they basically say that each safe converts at a certain valuation cap, they convert into their own series of preferred stock. So I've had founders go out and they thought they were being clever, and over the course of 8 months, they did 8 different safes with 8 different people, each at different valuation caps. And so we finally got to a Series A, and if we followed the safe strictly, we would have to create 8 different series of preferred stock. I mean, it's just like completely unwieldy. So we then got into this 8-party negotiation with these safe holders about how we had to change their safes, and yeah, we got there eventually, but any money they thought they were saving by using the safes, we spent multiples of that trying to clean it up later. So I think traditional convertible note structures have been around a lot longer. I think there's a reason for that. So I'd encourage you to think about that. And the safes, well, trendy. I wouldn't advise them. If you're taking money from Y Combinator, they will insist that their money's done on a safe, and that's, that is what it is. You don't have a choice. But when it comes to everybody else, you want to put them on a convertible note structure. Yeah?
So you're saying the convertible note's like a credit facility whereby all your investors are under one credit facility.
Exactly.
And then if there's a majority, then they basically control.
You can amend it. Yeah, so it's efficient later, right? As opposed to having to go to every little person. Yeah.
And then for the sake, is there a dollar amount? You're saying it's $2 million or below for convertible notes versus your Series C is usually $2 million or above. Is there a dollar?
No, I mean, I think I would put safes in the convertible note bucket in terms of how people think about them. Generally, if you're raising less than that. I think the thing with safes, though, is people tend to do them like one-off sequentially. They're not as thought through, and they're not a facility. So I've seen company, and is holding one safe, you don't know what other safes the company's signing. So for all you know, you have your safe, and they've gone out and done 20 others. You just don't know. The convertible note, everybody knows kind of how much is being raised and what the deal is.
Yeah, but from an investor perspective, a safe looks a lot more like the convertible note. Like, you don't have a liquidation preference. You don't have voting rights. You don't have a lot. As an investor, you don't have any of the protections you do with equity with a safe. So that's why safes are kind of used at the lower fundraising levels.
So you're saying they don't have the protections?
With a safe, no. Safe is kind of an agreement. I'm going to get equity in the future
Like the
when we do
convertible
it,
note,
like a
the same.
convertible note. You don't get those equity type protections that investor gets. You don't get those with the safe.
So I think the debt is actually more safe than equity. It seems more senior.
I mean, if in liquidation, it's clear that the debt gets paid first. I'm not sure what people say. I don't know. Does the safe get paid before equity? It's not clear to me. That's a challenge. Yeah, that's exactly right. I think Y Combinator thinks it's equity, but I've heard different opinions from different of the big 4 accounting firms. There's not agreement in the community on these instruments, so that's not a good thing. Yeah.
Do you have a sense why the investors prefer safes?
I don't know that the investors prefer them. I think founders prefer them because they are, I mean, they just hear about it a lot. I think Y Combinator's done a lot of good marketing around it, and there's so many companies going through YC now that there's just a bit of indoctrination, and so I actually think investors who know what they're talking about prefer traditional convertible notes, but founders think they're great.
So maybe then I'll re-clarify, why does Y Combinator like that?
I don't really know the answer to that, actually. Yeah, I'm not sure. I'm not knocking Y Combinator. I think they do a lot of great work. I disagree with them here on this.
Yeah, I think from my reading that I've read, I think it's the streamlining.
Yeah.
Like, it's faster, it's cheaper, they're standard, there's no negotiation. But I think those things are almost true to almost the same extent with a convertible note, and there's a lot more clarity and structure and historical dealings with that.
Yeah,
So.
that's probably right. Okay. last slide, then we can open it up to more questions. So I think when you're building a startup, I think you need to think about the fact that money is not money when it comes from investors. I think there are good investors out there. There are not so good investors. There's bad investors. It's like any business or profession. You know, there's a spectrum. So I think you need to think carefully about who your investors are, even people writing you small checks, because everybody who is an investor in your company is going to be a stockholder if they're not already, right? If they're a convertible note holder, they eventually will be a stockholder. They're on your cap table. They're going to have certain information rights under the law, and you're stuck with them. So, and it's often those tiny little investors who can frankly just be the biggest pain in the butt for a company. I've seen that a lot. So I think you want to think very carefully about who you're bringing money in from. And what I tell my founders to tell these early stage investors, like friends and family, is I think when people invest in an early stage company like this, they have to think about never seeing this money again. And that's how they need to think about this investment. It's extremely risky. And maybe you're pleasantly surprised and you find yourself in a Snapchat situation or even, you know, just a good exit. But I mean, statistically, you know, probably the company's not going to do well. I think founders need to make sure that people understand that when they're investing. And so taking money from people who don't traditionally invest in startups is not a good idea for lots of reasons. So that's sort of the friends and family thing. I think when you think about institutional investors, you know, VCs are not VCs, right? They really vary in terms of value they bring to the table and how easy they are to work with, how much expertise they bring. So I think you need to think about finding your investors as sort of two-way dating, right? They're checking you out. You need to be also, you know, thinking about this investor and talking to other companies they've invested in, not just companies that have done well. Probably more important to talk to them about companies that have not done well. And was the investor supportive? Were they, you know, in there with you in good times and bad? So I've just seen the wrong investors be no end of problems for a company in terms of distraction and expense and just, you know, just detracting from the business. And I've seen some investors be completely transformative for a business in terms of the value they bring and their network and how much they're willing to roll up their sleeves and really help a company. So you just need to think carefully about who you're taking money from. And I've seen founders take terms that are less favorable to them because they want a certain investor. And I think that can generally be a really smart trade-off. So money is not fungible. You need to think carefully about, and not just which fund, which partner at a fund, actually. Because it's a very personal relationship, right? The person who leads an investment from, I'm going to pick a firm, Kleiner Perkins. Yeah, Kleiner Perkins is your investor, but it's the partner at Kleiner Perkins who joins your board, and they're your primary contact, and they're the one in the trenches helping you. So you not only want to diligence the firm, you want to make sure you're dealing with the right partner at a particular firm. I think the other thing to think about with investors is, you know, I have founders who say, well, I want to raise money, you know, in June, so I'm going to start talking to investors in April. That's too late, actually. I think you need to think about relationships with investors as a very long-term thing. I was at a dinner a few months ago, and it was a leading VC. We hosted it together, and he got up and was talking about his relationships with founders. And he said that they track, this is a good fund, they track internally the length of time between when they first get introduced to an investor and when they ultimately write a check. I think it was like 15 months or something was the average. It's a really long time. It means there's companies that are less, but there's companies that are more. You know, it's a get to know you thing, right? And it's never too early to start that relationship. And then when you do want to raise, it's much easier to make the ask once you already have that relationship. And I think you see on Silicon Valley and, you know, other things out there, you know, you just go in, you pitch, and then they give you a term sheet. That happens, and I've seen it happen. I think it's not kind of usually how things unfold. There's usually like a longer courtship. And maybe, you know, this is a Series A fund, but you still talk to them early on. They may pass on your seed because they're not writing seed checks, but then when you do your Series A, you know, they're in your network and it's easy. So I think, you know, if investors are willing to meet with you and they're good investors, I would always take the meeting because you never know kind of when it'll be the right time. I think timing is also important when you raise money. I think you always want to be raising money at a time of position of strength. So coming off of really great metrics or a good inflection point, that's a really good time to be putting a valuation on the company. So I wouldn't just say, I want to raise money in a year. Think about where the company will be in a year. Are you just coming off a product launch? Are you just coming off the holiday season if you're an e-commerce company? Think carefully about where your fundraising will happen, because it's going to have a real impact on the valuation you can get.
Yeah, and a lot of investors will tell you that they understand cyclicality and they understand that, oh, things are up, things are down. We know how to average, it out. But I think just as a psychological aspect, a lot of people, although they may technically understand that businesses are cyclical and that you may be down now but will be up later, psychologically it's very different if you're coming from a position of strength after like a big seasonal sale or if you just sign a key partnership. So it's always good to be asking out there, seeking investors when you've coming from a position of strength and have recently done, something really good. Even though, as a technical perspective, they may try to tell you that, oh, they're a super sophisticated investor and they understand otherwise. I think the psychology is pretty strong there.
Last point, a plug for lawyers, but also other service providers. I think it's important when you build a business that you surround yourself with people who get it. And that's not just lawyers, that's accountants, it's valuation firms, it's people who are going to help you with your business. And look, some of these people are expensive, we get it. But the reality is you need to have those people in your corner, and it's never too early to have them in your corner because they will ensure that things are done right. And it also has a signaling effect to the market, believe it or not. And when you go talk to great investors, at some point they'll say, well, who's your counsel? And you'll say, we're working with Fenwick West, we're on their standard paper. They're like, great, check the box. They know that things are done properly, and they take a lot of comfort in that. And that's not just us, there's other firms like us, but firms who work with startups day in and day out. I think the same thing, like I said, comes when you work with accountants and other people that you need. You should start those relationships early. And we can get creative on the fee side of things with the right companies because we get it, right? We know dollars matter, so we can come up with creative deferral arrangements for the right startup that we really believe in. And we sort of take a very long-term view of things because the reality is we don't really make money off of an incorporation or even a Series A financing. We take a long-term view. When you eventually raise $100 million at your Series C, or Google buys you for $500 million, or you go public, that's actually when we start to see the benefits of our relationship. So in the early days, we're placing some bets, much like venture capitalists, and so we get creative on fees early on. That's it. You can ask us any questions. Yeah?
Yeah, on the topic of fees, what's
Yeah.
your rough sense for the dollar figure that founders have to pay out kind of before they hit their early funding rounds, whether it's the notes or seed funding, that they're paying out of pocket for the incorporation?
Yeah, that's a good question.
In terms of financial planning, budgeting.
So I can't comment on the technical side of things and what that costs. So you'd have to kind of build, for AWS and computers and stuff, you'd have to build that out. I know for us, a standard incorporation, kind of soup to nuts, all that founder stuff and forms and everything is about $5,000. I think if you want to do some of the other things that we talked about, so some IP work in terms of service and things, I think you could be spending 10 to 15 early on, which is frankly the deferral amount that most firms are willing to extend. That's how we operate actually with the right company, because the goal is to get enough legal work done that you're fundable actually. It's not like an all you can eat, let's do everything under the sun, employee handbooks, no. That's just not worth it. It's let's do the basics, get yourself funded, and then we can think about all the other stuff you need to do. So yeah, probably for that, and then you need to budget a little bit of stuff for accounting, although probably early on you could do QuickBooks, in the very early days, I suspect. I think most companies look to outside financial help once they've actually raised some investor money. The legal stuff, you don't have the benefit of waiting because you need that to raise money, so.
You mentioned that you start making money on that Series C funding.
Yeah.
So what's some of the criteria you use to filter companies that might approach you to pick the good ones?
Yeah, it's a good idea. And we're not perfect at it, by the way. If I was, I'd be a venture capitalist. I wouldn't be a lawyer. But we have a new business committee, and they look at, and I think other firms like us are probably similar, they look at every new engagement we enter into. So we look at how the company was referred to us. If a good VC sends a company our way, we're probably always going to work with them because kind of has a stamp of approval from an investor. Are they a repeat founder with us, right? That's super easy. We have a lot of founders who we work with. They sell a company, 3 years later, boom, it's like you rinse and repeat, you know? We always want to work with those companies. I think we look at the type of business people are building, right? We have some sense of kind of what investors are interested in the market right now. You know, qualifications and background of the team, what their plan for fundraising is. So there's a lot of intangibles, but those are the kinds of things that we look at. We get it wrong sometimes, I'm sure, both ways. Yeah. Did I miss anything?
No,
No.
that's right.
We only have so many hours in the day ourselves, so we want to work with, I guess, you know, companies we think are going to do well, but also people that we want to work with, right? At the end of the day, this is a relationship business, and I spend a lot of time on the phone with founders, and I want to spend my day not talking to jerks all day, but talking to, frankly, nice, you know, people I think are nice and cool and that I want to work with. So I think just like you're interviewing a law firm, they're probably, if they're good, interviewing you as well. And it should be a fit. It's like any relationship. This is somebody that, you know, should be someone who's your first call and that you feel comfortable talking to in good times and in bad, and that you feel you can trust, and that you feel really has your best interests at heart. And I think you can get a good sense of that after meeting with someone a few times. Yeah.
Can I ask a follow-up question?
For sure.
You talked about market trends. So at the highest level, can you share some insight on what's interesting or appealing to investors right now?
I mean, AI is still super hot, I think, as is the whole AR, VR thing. I thought that some of those might be a flash in the pan, but I've just seen sustained investor interest in both those areas. I think e-commerce is taking a bit of a hit lately. I think you're seeing investors retract from some of those investments because some of the exits have, I mean, you have Jet, of course, but you have some investments that have not, I think, been what people had hoped. Those are the obvious things. I mean, I think good SaaS companies always get funded, right? Those can be cheap businesses to build, but with the right revenue model can be pretty lucrative. Yeah. What are you seeing?
I think the machine learning AI,
Yeah.
I think, is huge. Even if it's not a direct machine learning progress, I feel like a lot of investors are getting really excited if your product somehow incorporates a machine learning component to it. Then I think, I don't know if this is anecdotal, but I think I've seen not so much people loving it, but investors being a little less worrisome or less scared of hardware.
Yeah.
I think a lot of physical products, physical technologies out there. I feel like there was a while where, you know, software was it's easy to launch, it's easy to scale. That's what investors were looking for. I think there's you've seen some appreciation, I think, for hardware more lately too.
I think, you know, digital health has been really tough. We do a lot of that work at the firm, and I think there's just not been a lot of like really good success stories to point to. I think with HIPAA and the really fragmented nature of healthcare, it's tough to build in those spaces. I think they're so important, by the way, though. I mean, I think those are really important businesses. They change people's lives. As we all know, our healthcare system needs help. But I think that's been a challenging area, and I've seen some investors pull back from that area as well. But you know, you need some big hits in an area, and people get excited about it and see that, oh, there's a path to monetization and a sale or an IPO, and then people get excited about that space. So.
Healthcare stuff, because it is a huge problem and a huge space to solve for,
Yeah.
but regulation really is kind of dampening a lot of the value that you can extract from there.
Yeah.
You mentioned patents earlier, but when you look at a tech company, what are you looking for in a patent filing? Would you care to talk a little bit more about that?
So I'm not a patent attorney. Believe it or not, we have people who just all day long, all they do is prosecute patents. They write and file patents. I think, well, there's a few things to think about. One is, you know, you can file a provisional patent to start, which is like kind of a shorthand version of your patent. I think you have a year to file your full utility patent. So I think with the provisional, sometimes they're useful because they're cheaper to file and you just like get it on file and you don't have to worry about the clock. So I think, you know, for those, I know our patent people sometimes work with companies where the companies can do most of the work. We just kind of like verify and file it. And then basically you punt all the real work to like a year down the road. So I think that's a good thing to keep in mind. I think what's patentable ebbs and flows, depending on how the patent office is feeling. They've really backed off like financial engine planning, for example. I think it's almost impossible to get a patent in that area now. It used to be much easier. So it sort of depends a little bit, but I think it's often a check the box things to be honest. I think there's not a ton of businesses where patentability is critical to the business. I think sometimes in a hardware company, it can be in the biotech space sometimes, but for most internet and consumer businesses, I think patents are like a nice thing to do at some point. I mean, I'm generalizing here, and there's something investors expect you've thought about at least. But I think for many businesses, they're not super critical and core, but something you need to think about at some point. I don't know if that helps.
For
Yeah.
instance, blockchain technology, that's
Yeah, I don't know what the patent office is saying about blockchain technology, actually. They may throw it in that financial engine. Yeah, they might, right? Yeah, I don't know. Cool. So how many of you are starting a company? I should have asked this at the beginning. The rest of you guys are just kind of interested? Fun topic. Okay. You want to be venture capitalists, maybe? Cool. Well, listen, our contact information is in the pamphlet we handed out, so feel free to send us an email or give us a call if you have a question.